Thank you very much, the moderator. I don't know if any established protocol has been made. However, in that regard, I would like to appreciate the president, the executive of Legal Eagles Initiative in conjunction with L.M.T Academy, as well as all members. Thank you for finding me worthy to present at this occasion. Having said that, I wouldn't like to go straight into the topic proper. And the topic is legal writing and drafting. I sent an earlier slide ahead of this program because it has been in my conduct that whatever I want to say should be put into writing so that at the end of the day, even after the class, all participants would have the opportunity to go back to the paper and purposely for future reference as well. I kindly and most humbly seek the permission of everyone to talk offline. I mean, not putting on my video. Please bear with me. Thank you very much.
Professor.
All right, so today's topic, we have, I'll be discussing today's topic under these headlines. The first one is the abstract, followed by the conceptual clarification, followed by precedents in drafting error-free documents. The next one is need to competently represent the intention of the client. The next one is basic principles of writing or drafting. We also have stages of drafting, habits to avoid in drafting, sentence and paragraphs, then the conclusion. All right, for the abstract, I said it is right to know that the tool of a lawyer is his words. By words, I mean not just verbally, but the ability to communicate efficiently in writing to his audience. You know, as a lawyer, your audience is not restricted to the judges alone. Your clients and the general public, all inclusive, are a part of the audience. And as such, dominant use of legal writing or drafting in conveying a position cannot be overemphasized. And in view of that, this presentation will explain the guiding principle, rules, and regulations. All lawyers, to include the budding ones, I mean to include the undergraduates, shall observe. That is a synopsis of what we are discussing today. And under the conceptual clarification, I would be saying that for the purpose of clarity, the term legal writing and legal drafting are hereby defined. Now, legal writing is the official medium of communication in legal practice. Under English grammar, there is something called jargon. Now, jargon are certain terms which are specified or specifically related to a particular field. And that is why if you don't belong to that particular field, people will say, you know, although people have overly used that particular word to mean nonsense. No, jargon does not mean nonsense. Jargon means you don't actually understand the statement of that person, maybe because that statement is only used in a particular field. Do you understand? So for the purpose of this occasion, which is, of course, the legal field, which all should know that legal writing is the official medium at which we communicate, be you in corporate world or in the litigation world or in the commercial world, I mean in the different areas or spheres of practice as a lawyer. I said writing, legal writing involves the analysis of facts, patterns, and presentation of arguments in documents, such as legal memoranda and briefs. One form of legal writing involves drafting, a balanced analysis of a legal problem or issue, and another. And another form of legal writing is persuasive and advocates in favor of a legal position. While on the other hand is legal drafting, which means the practice, technique, or skill involved in preparing legal documents, such as statute, rules, regulations, contract, and wills, etc. I now said legal drafting as a prerequisite to skills of a draftsman involves the knowledge of fact and law so as to put fact in a systemized sequence to give a correct presentation of legal status, privileges, rights, and duties of the parties and obligations arising out of mutual understanding of breaches and remedies. The summary of everything I've said is that while legal writing is official communication, analyzing facts, patterns, and presentation of arguments in documents, legal drafting on its own means the practice, technique, or skill involved in preparing legal documents, such as statute, rules, and regulations. Then I came to the conclusion that for the purpose of our discourse, I will harmonize the two terms to validly say that drafting is an art of writing and composition. Therefore, both terms shall be used interchangeably in the course of our discourse. I've tried to peruse through the topic given, and then I've seen that an attempt to differentiate between legal writing and legal drafting may tilt me towards discussing essay writing specifically, which is meant for another person, in the subsequent days. So, of course, to properly deliver the topic given, for the purpose of this class, we are going to harmonize and interpret writing to mean drafting. And that is why I said drafting itself is an art of writing. My reference comes from the available reference on the paper sent before this class, before this occasion, sorry. Let's go straight to precedents as templates to drafting error-free documents. In fact, that is the first thing we need to discuss. Either as a lawyer or as an undergraduate, the instrument of precedent, when I say precedent, I mean templates, something that has been done in the past, is very, very key. In fact, most of our senior colleagues in practice and even most of our lecturers in our various classrooms will always ask us, oh, if you know you want to, as an undergraduate, they will say, oh, try to treat past question, look at how questions are answered. That is precedent. If you are in practice and you want to write a brief, or you want to write a will, or you want to draft any document whatsoever, maybe any title document, or even you want to prepare an agreement in a commercial transaction when it involves commercial companies, they will always ask you to follow precedent. And as a matter of fact, most firms, be it commercial firms, corporate firms, or litigation firms, would always enjoin their officers to follow their precedents in that firm. And of course, I found it worthy to discuss, to start from that end. I said precedent I said this is a system of jurisprudence based on judicial precedents rather than statutory laws, which is advisable for an efficient legal practitioner to use in drafting good documents. Precedents should, however, be courteously used and must be used in the Nigerian context. Most often than not, people who want to draft, even as undergraduates, maybe someone approach you and say, please, the law, you know, now once you get to 100 level, they'll start calling you the law. And say, the law, please, can you help me to draft? The simplest among them is a tenancy agreement. Can you help me to draft the tenancy agreement? I say, no problem. Because you have your seniors who are now in practice, you just tell them, please, can you just please send me a template of a tenancy agreement? And you start amending, you know, you start dotting, you start to amend. I said, precedent should be courteously used and used in the Nigerian context. You must be very careful in adopting someone else's precedent. Precedent will only put you through as to how the form should be. It will not tell you what the substance should be. Maybe the drafts, the template that you got from someone, maybe borders on a property used for a shop, maybe a shopping mall. And of course, the instruction you receive from your own clients as a young wig, let's even say they just call you to bar, is maybe for a residential purpose. If care is not taken, you will start, once you adopt the precedent hook, line, and sinker, you have destroyed what I can call legal faith of your clients. And so you must be very careful in adopting precedents. I said forms and precedents must not be copied slavishly. Note that all drafts in the textbooks are correct. Hence, a need for one to be up to date in respect of any amendment. Are you there? In respect of any amendment arising as a result of statutory amendments. What I'm trying to say in that line is that even though some of us that invest so much in textbooks, we may want to adopt this format in our various textbooks. But believe me, you know that those textbooks are books of law, books on law, sorry, that project the position of the law for that time. If, for example, let's say company law, all textbooks on company law as it is today, if they have not been reviewed and edited, they are outdated. Why? Because the Company and Allied Matters Act, which they base it on, has been reviewed. So if you now take your company law textbook, which was written maybe in 2011 or 2019, prior to 2020, that textbook is outdated, and whatever you are adopting becomes obsolete. I said lawyers are allowed to use precedent in drafting, but must be adapted to the Nigerian context and relevant statutory provisions. Kindly note that the best way to produce error-free documents is to avoid ambiguities. We will discuss these ambiguities in the course of my discourse. How to avoid ambiguities, we will discuss it. Preparation leading to the drafting of a document should be well planned. It is not when you just want to draft that you start getting your materials. You immediately receive your client instruction as a lawyer, but even as an undergraduate, even though you are not yet a lawyer, and you may be charged for impersonation. Some undergraduates too, I can draft them. By operation of law, there are some documents that even a personal, someone who is not learned, that means someone, a non-lawyer, can prepare them. Maybe all these memorandum of understanding, people prepare up and down, okay? Only that it is only advised that lawyers, because of their expertise, they should prepare it. A non-lawyer can also prepare it. So as an undergraduate, if you now want to prepare a memorandum of understanding, maybe for a family member or for a friend, or maybe for even someone that contracted you based on your knowledge, you should be very careful that once you receive the instruction, you must start preparing. You will not start, you wouldn't jump into drafting first. What you do is to start preparing, start gathering materials, and you start sieving. Okay, drafts should be sent for perusers. After drafting, what we're expected to do is to send to friends or colleagues for them to peruse. I said that is, the document should be read thoroughly or carefully. It should undergo scrutiny and criticism. Yes, this part, most of us, we are allergic to criticism, and that is something everyone needs to learn, including me anyway. Everybody needs to learn criticism. In fact, immediately you are done writing, the first thing you are to do is to send it to people. Please help me to go through this. Do I make sense? Look at the clause. What do you think? You explain the transaction to that person, and you say, okay, based on your own experience, look at that document. What do you think I should add? What do you think I should remove? What are your observations? So once the person criticizes the document, then you go over it again. This involves any form of document you are writing, be it brief writing, that is in preparation to your court proceedings, or your various documents for various clients, for various transactions. There is need for someone to criticize. I said it should undergo scrutiny and criticism, that is getting the service of another legal practitioner or practitioners to criticize such documents. The use of short sentences is advisable to aid clarity, and finally proofread your documents, that is edit and check the draft for further error. Okay, the next headline is need to competently represent the intention of a client. Thank you very much for sharing this. I am on page 3 now. Need to competently represent the intention of a client. I said most times clients are illiterate. Now, when we say illiterate, for the purpose of this discourse, please, we don't mean, or I don't mean, someone that can't, understand a simple word, someone that cannot read and write. That is not what we mean, actually. In fact, by the provision of the Illiterate Protection Act, anyway, illiterate is anybody that is oblivious, that does not know anything in respect of a transaction. For example, now, as a lawyer is an illiterate in the medical field. A medical doctor is an illiterate in the legal field. So when we say an illiterate does not specifically or restricted to, even though it involves, it does not restricted to someone that cannot read nor write. We also mean someone that does not understand the transaction. So, for example, if you, as an Anglophone country, if an English-speaking country, which Nigeria is, if you found yourself in a Francophone country, let's say in Cameroon, which is even close to us, or in faraway France, and they now draft a document, and the document is written in French, you are an illiterate in that regard. Do you understand? So that is the definition of the illiterate we are talking about here. I said most times clients are illiterate and do not know how to go about drafting documents, and as such, they acquire the services of legal practitioners to assist them in drafting good documents. The legal practitioner, on the other hand, is to get a checklist from the client as regards to what the draft shall contain. As a legal practitioner, you must not allow the client to stipulate the type of document to be drafted. No matter how experienced the legal transaction the client is, he or she does not know the law. The law of the knowledge of the law is the preserve of the legal practitioner. Hence, it is the legal practitioner's knowledge and expertise that should be exercised in deciding which document can appropriately embody this transaction. Oral and documentary details of the transaction must be provided by the client. And in some cases, the legal practitioner must visit the subject matter of the transaction if necessary, to gain a better understanding of the transaction and to enable the legal practitioner draft an appropriate document. The short and fall of what I just said is that You don't allow your client to dictate what to do to you. What the client can only dictate to you is his instruction in respect of the transaction. Where maybe, let's say, a client approach you and say, please, I want you to help me to draft a tenancy agreement. I want you to help me to draft a commercial agreement that entails shipping. Your own is to as a lawyer is to ask him for the details of his instruction. He will not be the one to tell you what to do and what not to do. Let me cite an example. There was this client, I received a call from a client and said, oh, the law, please, I want you to help me to draft a, hello, can you all still hear me? Please, if you can hear me, say hi.
Yes, sir.
Okay, all right, thank you very much. Now, for example, a client called me and said, oh, Dilo, please, I want you to help me to draft a memorandum of understanding. And the memorandum of understanding, blah, blah, he was just giving me the instruction. And in the course of his instruction, I found out that it is not even a memorandum of understanding we need to draft. It is what we call joint venture agreements. And I laughed. I said, sir, what gave you the impression that it is a memorandum of understanding that you will need to draft? He said, Haba, is it not a memorandum of understanding, just for you to do something? And most clients always want to prove that they know so that they can charge you less, so that they will price you less. So that they will price you less. So you need to understand your law. Your law should be at the tip of your finger. So I told him, I said, sir, it is not a memorandum of understanding. I even added, I said, by operation of law, memorandum of understanding is not even possible. So you can't tell me, you can't say it is memorandum. So it is this, it is that, but I did not go into details because clients and their dicey character, they will get that logic from you and they will go and give it to someone else that they will give a lesser fee. So I just told him, oh, we are drafting this and it is because of this. I didn't go further. And he said, oh, is that it? And because of that, he paid even more than what he ought to pay. So you don't allow your client to tell you what to draft. Your client can tell you, please, Dilo, I want you to help me to draft, even as an undergraduate, I believe I'm speaking to undergraduate, they can even come to you. Oh, I want you to help me to draft a tenancy agreement. And you ask, tenancy agreement, oh, what are your terms? What are your terms and conditions? What are your instructions? It is in the course of his explanation, you will even know that it is not even tenancy you need to draft. Maybe it is even a lease agreement. Maybe it is not even a lease agreement. Maybe it is even a sublet agreement or a sublease agreement. And some other agreements like that. So you don't allow your client to dictate what document to draft. Now, basic principles of writing or drafting. We are getting there small. Drafting is an important skill that every legal practitioner needs to possess. Documents are drafted in English language because it is the language of law in Nigeria. Standard British English and plain English should be used in drafting documents. Therefore, law graduates should have acquired sufficient knowledge of English grammar in the course of their education. Legal drafting involves then the preparation of the following documents. I said pleadings. Now, pleadings is that document that you file in courts, okay, for the sake of a court proceedings. We have agreements. There are different types of agreement, varieties of agreement. We have the sale agreement. We have the deed of assignment. We have a land purchase agreement. We have a commercial transaction agreement and some other agreement like that. We have reports. When we say report, I mean statutory reports. Sometimes when you go on on behalf of your client when you go on to do search, maybe in CAC or in the land registry or whatever, there is need for you to produce or to give a report. It is. So there is a way or there is a format. It is also one of examples of legal drafting. We also have letters. We have legal opinion. Most often people write articles. You will see people writing articles. This falls under legal opinion. Just of recent, I also wrote, I penned down one on boycotting Attorney General's consent under garniship proceeding, and I said we can actually use sequestration. Sequestration, even though it has never been used in Nigeria, I was pushing for it that we can actually use it. That opinion of mine, or that article of mine, falls under legal opinion. And every article is right to the extent of the thought of the writer. Do you understand? So but however, there is a standard that which your legal opinion, your article must meet. If it does not meet that standard, then you have not written anything. We also have memorandum and some other things like that. I said, to continue, I said it consists of sentences. And each sentence, legal drafting consists of sentences, and each sentence must be a unit of sense. Now, Judge Cood, in his book, Legislative Expression of the Language of the Written Law, states that every legislative sentence consists of 4 parts. That means every description of the case to which the legal action is confined. And the last one, the conditions on performance of which the legal action operates. To start with, I said every legislative sentence must contain a legal subject and a legal action. The action that is that of the legal subject is linked to the subject by using a connective between the legal subject and the legal action. Now, let me start from the beginning. See, when we say the legal subject, I mean the legal subject, the description of that subject. That means let me say you are drafting an agreement, or you are drafting a memorandum, or you are drafting a report, whatever thing you are doing, there must be parties. The parties, you have to give a full details of that party, of the parties. Parties must not be anonymous in a document. And that is why, for example, people are doing a very great disservice to themselves. For example, let me cite an example. Let's say husband and wife, because they love each other and they can do anything for each other. Both of them contributed money to build a land. And in the course of description, maybe they now give it to an incompetent lawyer. And in the course of the description, the person says, Mr. and Mrs. Alalafia. Now, when you say Mr. and Mrs. Alalafia, in law, you have only mentioned one person. And the presumption is that you have mentioned only the husband's name. So for clarity, you have to state it in full. Mr. A, blah, 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 Alalafia, and Mrs. B, blah, 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 Alalafia. You have to state their full name, not that you just say Mr. and Mrs. Alalafia. No, that Mr. has a full name. Let's say Mr. Muhammadu Buhari and Mrs. Aisha Buhari, not Mr. and Mrs. Buhari. So there must be clarity as to the legal subject. A legal subject cannot be a thing. Please note, it cannot be a thing because it is only a person that can be conferred with rights, powers, and privileges. And so when we say a person in law are two. A person in law is two, and that we have the natural person and the artificial person. A natural person is a normal human being. An artificial person is any incorporation made under the Company and Allied Matters Act. Company, any company, once you incorporate a company, then it becomes an artificial person. So a company such as Guarantee Trust Bank Nigerian Limited, such as Nigerian Breweries Nigerian Limited, or whatever company is an artificial person. All right, the next one is legislative action. I said this is the action required of the subject, and this action is linked to the subject by using a connective. The connective depends on whether the legal action imposed on the subject is mandatory, permissive, or prohibitory. For instance, the connective expression shall is mandatory. Anytime you see in a document, maybe in the course of your writing, you say the assignee shall, or you say the assigner shall. Okay, for example, you want to say, let's say Mr. A transfers the property to B. And in the course of your drafting the argument, I mean the document, you have to say that upon the receipt of 150 million naira being the consideration for the landed property, the assigner shall, you have to put it, shall, which is mandatory, shall transfer ownership of title. So you have to be very careful. Not that you will now be writing it as if it is persuasive. I said, okay, the use of may or may not is permissive, while shall not is prohibitory. So, you know, any form of agreement between parties becomes a contract, particularly when consideration is attached. All agreements are contracts, but not all contracts are agreements. What makes an agreement a contract is when a consideration, such as money consideration, is attached and it becomes enforceable. A contract that is not attached with a monetary consideration or with any consideration that is valuable in the eye of the law is a mere agreement that is not enforceable. So therefore, whenever you are writing, you need to be aware of the legal subjects that you will be using. The legal action, the legislative action you will be using. If it is compulsory, use the word shall. If it is not compulsory, use the word may. If it is prohibitory, use the word shall not. And some other ones like that. All right, let's continue. I said the case. Now, I said the case states the circumstances in which the legal action can be involved. That means in stating the case, the expressions such as when, where, all these WH words. Maybe you want to prohibit that the assigner, when I say assigner, I mean someone who is selling a land. Now, and the assigner shall not deny the payment of, you can't deny that someone paid to you, shall not. In the event, then you put the circumstance there. Then the last one is the condition. I said conditions may be prescribed, which have to be fulfilled before legal action can be taken. Where there are such conditions, no legal action can be taken until they are complied with. Expressions such as if and unless are used in stating conditions. It is not all legal documents, or in the course of drafting, it is not all documents that conditions are attached to. But there are some transactions that it is until when something happens, when something happens, that is when the contract, the agreement between parties can come into effect. So if there is any condition attached to the instruction of your client, you need to put it there. However, some legal writers have criticized the above form, like I said, by stating that a simpler form should be better to help legal practitioners in drafting. So I said a sentence should be arranged in the manner below: subject, verb, and object. A very good example of subject and predicates. What do you call it? Subject, verb, or what do you call it in this secondary school? I think in GS1, everybody, we are all taught that in subject and predicate. They will tell you subject is the doer of an action. Then predicate is divided into two. the verb, and the object. The verb is the action word, then the object is is the receiver of that action. So just exactly here, I said the subject being the actor, that is a person empowered to do or refrain from doing an act. The verb states what is to be done or not to be done. The object, on the other hand, is the thing or person being acted upon. In using the above format to prepare a good draft, the legal practitioner should state precisely, in a clear manner, what ought to be done by the person or thing involved in the body of the draft, and should also go an extra mile to state what the person or thing should refrain from doing, and the person or thing in which the essence of the draft is to be acted upon. Now, the proper language to use, as earlier stated, is the standard British English and plain English. For these will help easy understanding of whatever document that is to be prepared by a legal practitioner. To be an efficient legal writer, the legal practitioner should have the proper understanding of standard British English, particularly in respect of the following: 1, spelling; 2, sentence structure; the next one is paragraphing; the next one is grammar, capitalization, and punctuations. I said, to avoid ambiguity, nouns should be preferred to pronoun, even at the cost of repetition. For example, let's say the parties to the transaction you are drafting, they are male. Under part of speech, pronoun is used instead to represent, or you use it instead of a noun, the way primary school people will say. So if you want to use the word he, you are going to use he for both of them, and that one, it becomes clumsy. We will not know which one, who is who, by the time you are saying he should give to him. Okay, let's say it is only the feminine gender that has what do you call it? All these she, her, and I think one other one. But for the feminine gender, our own is too identical. So you must be very careful as to how you use your pronoun. In fact, it is even advised that don't use your pronoun at all. Use your nouns, even at the extent of committing repetition. Why? Because it makes your document concise. It gives you a clarity. We know who is performing what function and who is not performing what function. I said adjectives and adverbs should also be used carefully because their meanings are less clearly fixed than that of pronouns. Futures and advantages, futures or advantages and pitfalls of this document. I said there are several stages of drafting, okay, which include, taking and understanding instructions, analyzing, classification and research, design, planning and outline of the draft, composition, scrutiny, editing, and checking the draft. Let's take it from the first one. Taking and understanding instructions. I said it is crucial for a legal practitioner to obtain from his client full instruction prior to drafting a document for a conveyancing transaction or writing of briefs. Instructions may be given by client either orally or in writing. Where instructions are oral, the legal practitioner should write down the instruction taken from his client. Lawyer to make adequate preparation for the conduct of the interview. He should get a pro-formal interview ready, which will contain all pertinent questions he intends to ask. A lawyer should be courteous to a client and make him relax. A lawyer should be sure he gains the client's confidence and attention from the beginning. Please, I need to state it at this juncture that lawyers, we need to maintain our mental health peace. If you're having relationship issues or you are married and your wife is giving you issues, you need to balance everything, because if you are troubled, you will transfer that trouble to your clients and you module up. In fact, we also are, we are doctors too, and we determine the fate of a client. If you handle the client's case in an arbitrary manner, the client can even charge you for negligence. Anyway, I said a lawyer should be sure he gains the client's confidence and attention from the beginning. should be in control of the interview all through the interview period. A lawyer should not allow his client, irrespective of how experienced he may be, to dictate the legal format the transaction should take. A lawyer must look and feel pleased to see his client. A welcoming smile may be good, but the lawyer must not appear patronizing, because we are not allowed to advertise in law. A lawyer's mood throughout should be sober, decorous, but not mournful. I hope you understand all this language. Don't be as if you are mourning, but then you should be sober, not as if you would appear like Naira Marley. You can as well appear like a Simi. Anyway, that's just on a joking level. A lawyer should take his client through the question and answers and tick off answered questions as the interview progresses. Counsel must not seem too probing in his exercise. A lawyer should be careful and consider the totality of the instruction received. Clarify and resolve any ambiguities. Ask for further elucidation on areas which appear to be in doubt. A lawyer should put instructions in legal form and add such legal provisions necessary to give real effect to the client instruction. Note and identify the intention of the client vis-a-vis the intention of the other parties in the transaction. The design. I said this is the act of working out the form of something by making a sketch, outline a plan. A legal practitioner must make or work out a plan for the draft. A draft must have a good design. For example, whether the document will be divided into parts, chapters, clauses for easy assimilation. The order, the document should be such an order that will make it most readily understood. The idea should be arranged in some order, in order of sequence, accuracy, and precision. All superfluous phrases. Hey, I need to hammer on this, like we will say. I'm still one of you guys anyway. I will need to hammer on this. When you see law undergraduate writing articles, you will be marveled by the superfluous statements they make, which are unnecessary anyway. You will see them saying a lot of, grammar that entails verbosity, all in the name of you want to sound, my fellow brothers and sisters there. When your seniors, when they are contesting for election in their student union government, you know how these people they come for, what do you call this thing? Hey, someone should remind me, please. A day before the election, they usually hold something.
Manifesto.
What do you call it?
Manifesto.
Oh, manifesto. And you start seeing them, doing all sort of stunts. My name is blah blah blah. Sagaciously meant. No. Those are superfluous statements. You can make your statement without verbosity. So all superfluous phrases should be avoided, particularly when you are drafting. Legal language should be precise and accurate. Each sentence should bear an order that will most readily and clearly bring out the meaning of the sentence. The next one is planning and outline of the draft. Now, I said this is the cognitive process of thinking about what you will do in the event of something happening. That is, the plan should have the will and intention to carry out some action that is derived from the design. There should also be a schematic or preliminary plan acting as the outline of the draft. The next one is composition. I said this is the spatial property resulting from the arrangement of parts in relation to each other and to the whole. That is the way in which the draft is composed. The draft should be created by arranging several precedents to form a unified whole. So what I'm saying in essence is that you can get precedents, you get many as you can. You look at them, you look at everything. It is not as if I'm saying you pick the best. You pick the best, you pick the ones you think you can work with, and you harmonize. The next one is scrutiny. This is the act of examining something closely. As for mistakes, okay, for a draft to be error-free, a legal practitioner draft should undergo scrutiny, that is getting the service of another legal practitioner or practitioners, editing and checkmating the draft. I said this is the last stage of drafting. After a draft has undergone scrutiny, a legal practitioner should edit and make omissions or additions based upon what is scrutinized and give you a final thorough check to see if it is standardized. Habits to avoid in drafting. For a drafting to be good, a legal practitioner has to avoid certain words, which if used will act as pitfalls to good drafting techniques. Such words as follows. 1. Words and phrases that are uncommon and intricate expressions. I said a legal practitioner should avoid words or phrases that are uncommon or having many complexly arranged elements. That is, elaborate or complex words should be avoided. Let me start an example. Most times, lexicographers amongst us, when I say lexicographers, I mean those people, the writer of a dictionary is a lexicographer. So I mean, if you are also the type that you also consult the, what do you call it, the dictionary, and you now your role model or your mentor is Patrick Obayagmo, the crinkum crankum. For example, Professor Wole Soyinka, there was a time they were talking to him on a TV station, and in one of the statements he said, "Oh, when I was young, and I usually ran away from house chores like that because I don't want. So each time they call me, I would just tell my mom. I used to tell my mom, oh mom, I want to go and ejaculate the aquatic environment of my internal contingency." And the author said, "What? Sir, what is the meaning of that?" I always said, "Oh, sorry. It simply means I want to go and urinate." Fantastic. If we break down what he has said, I want to go and ejaculate. Ejaculate in biology means to pass something out. The aquatic environment, anything aquatic is watery. Environment of my internal, of course, internal contingency, something that is dirty. So the breakbot, even though we appreciate him because he is a literature, is someone that appreciates literature. When you are drafting, you should be very careful of inserting all these literary terms in your legal, in your draft. A very good example of what I sent in a material. This material is not legal drafting. This material is a presentation. When you are writing as a normal person, it is not as if you are writing to represent a client. Maybe you are writing maybe you want to speak in a particular event, just like I'm doing. That is not legal drafting. Except if they ask you to come and talk on a particular law or on a particular area of law, then it becomes legal drafting. But if you just want to talk generally, just like a speech, let me put it that way, a speech, maybe closing remarks, you can do whatever, you can put whatever stunts, whatever grammar you have crammed, you can put them in those speech. Opening speech, closing speech, opening prayer, whatever you can say. But once it involves drafting, you must stick to grammar alone, English, so that you don't define the fate of your client otherwise. The next one is a legal practitioner should avoid using statement that contains more words than are needed and should also refrain from using excessive words in order for the document to convey a simple meaning. A large number of verbose examples are found in old legal documents. Some of the words used in this document are repetitive, and this type of drafting should be avoided. For example, buys, purchases and sells, alienate and takes legal interest in land situated and located at, abeg, like we will say, abeg, what is situated, what is located? But even for me in practice, anytime I just use situate, my boss sometimes will still say, no, just make sure you stick to the 1980 something, because lawyers. And it is because most lawyers are still stick to this aged practice because lawyers raise unnecessary objections in court. But of course, you should reduce your verbosity. That is the message. Archaic words and expressions should also be discouraged. The use of old words should be avoided and be replaced with modern words. For example, do it. He who do it. No. You don't say that kind of a thing again. Example of archaic words are whereas, aforementioned, whereof, herein, after, herein, at, dot. I beg, like we will say, people are still using these words. But of course, if you don't use them, it doesn't mean it does not mean that you have prepared a defective draft. They are now, even the Supreme Court are now saying that people should You know, law is dynamic. And so by draft, the draft also should be dynamic. I said this should only be used where they are absolutely necessary. So you stick to it. Also avoid technical terms and abbreviations. It is unnecessary to repeat the words we are asked to introduce every document. Changing language, different words should not be used to say the same thing in the same document. Do not start with landlord and end with lessor. Be consistent throughout. Consistency is key. If you have used the word lessor, let's say for instance, you want to draft a tenancy agreement. The parties in a tenancy agreement are landlord and a tenant. So you should not use the landlord here in after. When we now go to the third line, we are seeing the lessor. By the time we move to the fourth line, we are seeing assignor. So you don't go gaga with that too. If that is just on a joking level anyway. All right, Latin words and phrases. Dear 100 level students. Dear 100 level students, be very careful when, you know, immediately you are in 100 level, you started cramming all these, what do you call it? You start to cram all these legal jargons, what we call legal maxims. And before you know it, you start saying, oh, quick plantator solo said it. The more deducting cosasua, the more that cool non a bit. Latin words is just to train you as to the origin, as to the history of a particular area of law. It is not that you will now start imputing them, putting them inside, what do you call it? You start putting them inside, what do you call it? Inside drafts. No, you don't do that. You don't do that. You use, I said, in drafting, sentences should be written in plain English, devoid of Latin words and phrases. The use of Latin words and phrases should be avoided when drafting documents for a client, because not all clients understand its meaning. For example, rather than writing the Latin word in a phrase, e interepa omnibus bone voluntatis, you don't need to write all those jargons. What you just need to write is, and peace to his people on earth should be written. Use plain everyday language that can be understood by both lawyers and non-lawyers, and don't use abbreviation. If you want to say Federal Capital Territory, say Federal Capital Territory. Don't say FCT. However, if it is a must you use FCT, you can now say it this way: Federal Capital Territory. Herein after referred to as FCT. You have introduced FCT as what? As Federal Capital Territory. Or after drafting, you impute an interpretation clause. Then interpretation clause will now include, FCT means Federal Capital Territory. You don't put FCT and you believe everybody understands FCT. No. Use of pronouns instead of nouns, adverbs instead of verbs. I said to avoid pitfalls in drafting, nouns should be preferred to pronoun, even at the cost of repetition. Verbs should be used instead of adverbs. Adjectives and adverbs should also be used carefully because their meaning are less clearly fixed than that of noun. Improper use of words. A legal practitioner should avoid improper use of words. Words like shall, will, when, where, etc. should be used at the appropriate places. In ordinary use, will, used in the first person applies a wish or intention. Ensure that the intention of your client is properly reflected. Will or any gives some kind of discretion, but for an obligation, use the word may. The court in Oguche versus Umba, you will see the what do you call it? You will see the references that I made for this particular material. Advocated that MUST must is more compelling and obligatory than shall. Improper use of and or, and is used ordinary in conjunctive. So what I mean there is when you say and is conjunctive, when you say or is disjunctive. So when you say Bola and Tunde, they are together. When you say Bola or Tunde, they are different. Yes, the next one is clumsy and inelegant words and phrases. A legal practitioner should not use words that are clumsy. That is, words or phrases that are difficult to use because they are not elegant or graceful in expression. The next one is redundant words or phrases, jargon and technical terms. A legal practitioner should avoid using words and phrases that are no longer needed or useful in drafting documents. He should avoid jargons because such words or expressions are not accepted. However, it is permissible to use technical terms and terms of art where they are understood in the trade or profession. That one is allowed. When the document is intended for persons engaged in that trade or profession, aid to clearness and accuracy. For a document to be well drafted, it must be clear and accurate. Properly, the following will aid a legal practitioner to draft an accurate and clear document. 1, punctuation. A legal composition must be properly punctuated. Punctuation aids clarity and enables the sentence to convey the intended meaning. Punctuation marks must be used correctly if they are to serve a useful purpose. Now, the use of proper punctuation marks is an essential part of good drafting. The punctuation marks that may be used are full stop, comma, colon, semicolon, bracket, question mark, exclamation, question marks, hyphen, apostrophe, etc. I refer to section 3 of the Interpretation Act, 1964. That one states that punctuation forms part of an enactment and is taken into account in construing it. So be very careful how you punctuate when you are drafting a document on behalf. In fact, one thing you should have at the back of your mind is that any document that you draft is a subject of interpretation before the courts. So if you draft it inelegantly, if you draft it anyhow, just like you draft a normal speech, it creates a problem. And that is why in a law firm, in a standard law firm, once you are done drafting, you keep sending to at least 3 lawyers to go through for you. The next one is capitalization. Of course, you know where to use your capitalization. Use of definition. I said when words are used in drafting a document, it is advisable for a legal practitioner to define it, which he believes will not be understood by a client. If you believe a word will not be understood by a client, please give it a definition. For example, when a legal practitioner uses like lessor, lessee, mortgagor, he should define such words to give it its original meaning. Now, use of interpretation clauses. You will see that even in our laws, we have interpretation clauses. So also you can put in interpretation clause in a document, particularly when you see that you have made use of several semantics that need to be interpreted. What in use to avoid context and ambiguity, what that convey one meaning should rather be used. Stop putting on all this big grammar. Let's go straight to the use of, I said, Conveyancing Law and Interpretation Act 1964, section 14 and 18, both sections refer to make use of words like month and person to achieve clarity and accuracy. The meaning of such words should be explained. Month means a calendar month. These are laws that gives interpretations to statements like that. You go to brackets. Yes, I said these are in pairs, open and close brackets. They are also called parentheses. Generally, they are used to enclose or aside or afterthought, which further clarifies a sentence. Brackets are used in legal documents to enclose nicknames given to parties to a transaction, e.g., the seller, the buyer, etc. They are also used to enclose abbreviations or equivalents of figures in words. Now, there are 2 types of brackets, namely the round one and the square one. Now, the square bracket is only used in quotation where words which do not belong to the quotation are inserted in the quotation for sake of clarity. Then, while round brackets are used in all other situations, okay? Except in citation of certain journals and law reports. Certain journals, you can see they say certain journals. That means if a journal has specified that you should not use the round bracket, that is when you don't use it. But majorly, it is being used. Schedule. This is an annex or an appendix. It's like an attachment to a statute or any document, which you can also prepare, maybe a deed of assignment, which aids clarity. They are part of enactment. This makes the document easier to read. Details are banished to the schedule so that the reader is not distracted from the point of the document. Repetition of preposition. This will be done in a logical manner in order to convey the essence of the legal document. Prepositions should be repeated where and when necessary for sake of clarity. Enumerating particulars and exclusion of the jus generis. Now, when you are in 100 level, and I'm very sure even in 200 level, legal method and Nigerian legal system respectively, they taught you rules of interpretation. There's something we call a jus generis. In fact, the best way of explaining a jus generis is what we call etc. You know, when you say etc means you can no longer start mentioning. When we say mention names of carnivorous animal, lion, tiger, leopard, the way you always do it in your secondary school days. And they will now say etc. because it is impossible for you to mention all carnivorous animals. So you said etc. A jus generis rule is not saying that etc. and so on and so forth, that etc. must be defined, must be construed to restrict to the ones you have earlier mentioned. Do you understand? So what I am saying in essence is that you cannot say that, that etc. will now include, let's say, a rabbit. A rabbit does not fall within the classes of those animals you have earlier explained. That was just the simple explanation for a jus generis. And I said a legal practitioner has to determine the number of particulars by mentioning them one after the other and avoid the use of a jus generis rule, which means of or as the same kind, because this might lead to ambiguity. Most times it creates ambiguity in courts. And so it is always advised that you don't use it at all. Computation of time. These are used to give a clearer understanding of a legal document. Let your document be definite as to the time the document will come into effect and as to the time it will what? It will come to an end. There must be a clarity in that regard. Then the last one I said clarity, which explained everything. I now said, if you look at that clarity, I referenced something there. If you go to the case I referenced, that's the case of Consolidated Contractors versus Masari, 2011, 3 Nigerian Weekly Law Reports, part 1, 2, 3, 4. In that case, the court just said every word must be concise and precise. Note that a word used can change the fortune of a party. If you use a wrong word, it can change the fortune of your clients. If you use a word that you ought not to use, it can destroy your client and it can make your client. So you have to be so careful. All right, we are coasting towards an end. Let's go straight to sentence and paragraphs. I said sentences. A sentence must begin with a capital letter and end with a full stop, exclamation mark or a question mark. Sentence should be written in plain English. Then what are the formats? Length of sentence. A long sentence should be avoided at all costs. Instead, such a sentence should be redrafted into series of sentences. The length of the sentence depends on the idea in the sentence. Several scholars have given different ranges of words that should be contained in a sentence, but a lot of them have agreed on a maximum of 28 words in a line, in a paragraph, while others range from 20 words to 25 words. Thus, a sentence must neither be too long nor too short. It should be short, but must convey the meaning of actions to be taken or message to be conveyed. The next one is use of active words and not a passive voice. I said short, familiar words should be used instead of long, unfamiliar words. Concrete words should be preferred to abstract. Words given the same meaning should be consistently used. Technical words should be used sparingly. Okay, for example, Fejiro broke the glass. Okay, and not the glass was broken by Fejiro. So when you are writing and you always use the word by, be very careful of your bye. Paragraphing technique. Sentences must be arranged in paragraphs. Each paragraph consists of a thin idea or argument. The division of a text into paragraphs makes for easy reading. Length of paragraphs. Suggestions have been given about the right length of a paragraph, ranging from 5 sentences to 6 sentences. In some cases, they may be redrafted in clauses and subclauses, duly numbered. For example, affidavit should be numbered. Numbering and identification of paragraphs. This is necessary in order to make clarification in the legal document. In essence, sentence must be arranged in paragraphs, and each paragraph should consist of a thin idea or argument. Length of paragraphs ranges from 5 sentences to 6 sentences. Expression as to time. This is where we are. People don't, sometimes your boss, your senior, or your lecturer can even give you a document to interpret. We just give it to you. Please, what do you think they are saying there? This, what I'm about to explain, are what gives you a proper interpretation of a legal document. And so whenever you are drafting, you must be very curious, and you must be very careful, and you must be very precise as to which of these words you want to use to express your time. In computation of time, there is the problem of whether to reckon exclusively or inclusively the stated date or date in legal documents. I said here are some clarifications. The first one, on. When used, it is interpreted as inclusive of the stated date. For example, when you say on 10th November 2021, includes the stated date. Okay, that it means the whole day. So when you say on the 10th November, that means you are saying that the action you are talking about starts from that day. The next one is FROM, from. I said when used, the stated date is construed exclusively. Example, from 10th November 2011. Now, I said it excludes the 10th and starts running on the following day, 11th November 2011. So when you now say, while drafting, you said the assignee should pay from 10th, immediately you use from, based on the Interpretation Act. FROM means that you are excluding 10th, that day, from, from the date at which the action should be done. That means the date, the action is expected to be done the next day, not that exact day. You may say about English. Now, when they say English is quite, that's why I said this is legal drafting. And that's why I said, I've tried to look at the two things, legal writing and legal drafting. I've seen that, okay, what you want me to discuss about is specifically how to draft. Someone that if you are writing, if you are writing normal essay, no problem, you can use it. But when you are when you are drafting, when you are representing your client in a transaction and you are putting his instruction into writing to comply with this particular law, note that immediately you use the word from. From that date you have stated, what you meant is that the action should be done the following day. From 10th November 2021, it excludes the 10th and starts running on the following day, which is 11th November 2021. You can see the reference that I gave to you there. Cartwright versus MC Comic, 1963, You find it there. Stewart versus Chapman is a 1951 case. All right, let's continue. AT, I said this is used when it is intended to take into account fractions of the day, e.g., commences at 10 a.m. The interpretation is that parties intend to reckon with fractions of day. What I mean fraction is that you are not talking about the whole day. What you are talking about is that there is a particular time you want the action to be done. And so it is from that day. It is from that time. Unlike when you use on, you are talking about the whole day. From 12 a.m. of that day to 11:59 p.m. of that day. That is what you are actually saying. So, but when you say at, you are being specific as to time. When you use the word AFTER, when an event is stated to take place after a named date, the date of the event is to be excluded. E.g., the agreement commences after the payment of the sum of 1 million naira. Okay, you can see my reference there. I was just compiling cases that discuss all these things. To, if a legal document expresses from 10th November to 15th November 2021, I said due to the use of from, 10th is excluded, but it is not clear whether 15th is included because of the use of to. Now, to avoid ambiguity, it is better to add both dates inclusive. You can say I quoted it, both dates inclusive or the 15th day inclusive. The next one is till or until. I said this does not give clear indication of inclusiveness or exclusiveness. To avoid ambiguity, use till and including, or you use till but excluding. So e.g., till but excluding 10th November, till and including 10th November. Now, the next one is at the expiration of. Now, at the expiration of, look at that phrase. I said it means not later than the expiration of, or at or after the expiration of. Now, if within a reasonable time is intended, it should be so stated. Day, the next one is day. What do we mean by day in law? A day. What do we mean a day? I said this means the period of 24 hours, starting at a midnight, that's 12 o'clock a.m. and ending on the following midnight, 11:59 p.m. Generally, it is used to mean the whole day, but where fractions, that is, commencing at a particular hour of the day, is intended, it should be clearly stated by using the word at. Now, working day. Okay, the next one, sorry, is clear day. Simply means the period of 24 hours, starting at midnight, excluding fraction of a day. Working day. This means Monday to Friday, excluding public holidays, Saturday and Sunday. Please, kindly note, according to the Interpretation Act, a Sunday is not an official day. Please note that is not an official date. However, Saturday ordinarily ought not to be an official day too. But the court or the law always allows that where parties consent that this thing should be done on a Saturday will be will be construed to be a working day. So Saturday is left aside, but you cannot consent on Sunday. Sunday is exclusively taken from the discretion of parties. But Saturday is left alone. If you like, you take it a working day. And if you don't like, you don't take it a working day. And that is why in some private organizations, Saturday is a working day for them. But nobody can say Sunday is a working day, because that one is by operation of law. The Court of Appeal, I said, if you look at it, I refer to the case of Essen and Essen. I said the Court of Appeal took decision notice of a Saturday as a work-free day. In that case, however, if parties consent to that Saturday should be, of course, it would. And that to be done on public holiday shall be duly done if done on the next day. So that means if the law says you should do something and that thing falls on a public holiday or on a Sunday, the law will take it as if you did it the following day, which is not a public holiday. All right. However, where the act is to be done within a particular period not exceeding 6 days, all the days shall be left out of account in computing the period. For example, if you go to your banks, maybe you did a transaction and you want them to review it, they will say 6 working days, to exclude Saturday and Sunday. A week, this is 7 days. This is 7 clear days, starting midnight of Saturday to the midnight of the next Saturday. However, parties can state in the agreement that the period begins at midnight of any particular day of the week to the midnight of the corresponding day in the next week. For example, midnight Monday to midnight Monday. Month, generally months can be lunar or calendar months. In Nigeria, a month refers to as a calendar month. On the meaning of calendar month, Section 18 of the Interpretation Act defines it as a calendar month ends upon the day in the next ensuing month having same number on that on which the computation began. But if the next ensuing month has not number this month, then example, calendar month from 28th March expires on 27th April, 29th January expires on 28th February, 31st August expires on the 30th September. What I'm trying to say there is that in law, you know the way we always count now, they said January to January is 1 year. No, you didn't say that. Or when you say February to February is 1 year. No, it is minus 1 day. Minus 1 day. Whatever you want to calculate, minus 1 day. For example, let's say someone loan you 1 million naira. And you now state in the agreement that someone pays you, loan you 1 million naira on the 5th of February 2021. And in the agreement, you now say the person should pay on the day it clocks a year. So that means the person is going to pay the money on the 4th of February 2022. You will not say 5th of February 2021 to 5th of February 2022. That is a year and 1 day. If you calculate it, a year and 1 day. It is always minus 1. So 5th of February 2021 to 4th of February 2022 is a year, not 5th of February to 5th of the 5th of February 2021 is 5th to 5th of February 2022. No. You remove a year. All right. I said the calendar month is calculated according to the Gregorian calendar. Now, a year is a period of 12 months, usually calculated from 1st January to 31st December. Where a contrary intention is needed, it should be clearly and expressly stated. The next one is within a reasonable time or as soon as possible. This one under equity, it is always there. They will always be putting it within a reasonable time. I said within a reasonable time or is common in commercial documents and in some cases applied. The phrase should be avoided as it is difficult for two persons to agree on what is reasonable time. Where possible, specify the time frame. Meanwhile, as soon as possible means shortest possible time or within a practical time, but it is imprecise, unspecific, and its construction depends on circumstances of each case. Both phrases should be avoided as much as possible. However, where there is uncertainty or the performance of act or obligation depends on prevailing circumstances, their use becomes inevitable. So if circumstances determines that you need to use it, of course you wouldn't have any choice. The next one is not later than or not earlier than. I said in both cases, the stated date is inclusive in constructing the period of time. Not later than, or when you say not earlier than, in both cases, the stated dates. That means when you say not later than 10th December, that date is inclusive. Then the next one is forthwith, what we call immediately. I said both words connote prompt or without delay. They are imprecise and their meaning depends on the circumstance of each case. Forthwith is archaic and should be replaced with immediately. Legal practitioners may be required to draft several documents. These include internal memorandum, letters, legal documents, legal opinions, and advice and pleadings. Drafting rules must be followed when drafting documents and the right format adopted. Also, the appearance of legal documents is important. Documents should be well laid down to aid readability, if there is anything like that. All right, conclusion. Legal drafting should be precise and accurate. At all times, the draftman must keep an eye on the rules of legal interpretation and the case law on the meaning of particular words he may employ to use. The ability of the best advocate to include a solicitor is that they can take a complex subject, something that is broad, and express it in simple terms. Simplicity will always be more powerful than complexity and verbosity. I can repeat that statement again. Simplicity will always be more powerful than complexity and verbosity. I therefore enjoin everyone be as brief. Some people are disturbing. Can you mute yourself, please? Thank you. I therefore enjoin everyone to be as brief as possible, but not without capturing all necessities in a document drafted on behalf of the client. Now, I ended it with something, and that thing I've put it into italics, and I as well bolded it. I said, nothing is perfect. Please, you need to, even though I've tried to say you have to be careful, blah, blah, nothing. Yeah. And that is why let the greatest lawyer of our time, the likes of Chief Afe Babalola, the likes of Chief Wole Olaonepeku, the likes of even let the late Chief Ganefa when he came back to draft a document, it can never be perfect. And that is why it is so easy for lawyers to contend, to argue, to object to any form of document in court. In one way or the other, that document will be defective. So it cannot be 100%. Okay? Nothing is perfect. But be careful of making silly mistakes. Because no matter how your mountain of defense sounds, now look at it now. I'm using literary appreciation because of course I appreciate literature. This one now, your mountain of defense, that one is not allowed in a draft, which is because this is a presentation, and that is why I'm using that kind of language. I said nothing is perfect, but be careful of making silly mistakes, because no matter how your mountain of defense sounds, you will always look jack and incompetent. Thank you very much for having me. I will graciously hand over to the moderator in case there is any comment. Thank you very much.
Thanks so much, sir.